Hey boys and girls, today we are going to discuss the duties of an executor under a will under Singapore law. This is an essential topic for anyone involved in estate planning or administration. We'll also look at a High Court case that discusses these duties. In case you don't already know, an executor is a person appointed in a will to administer the estate of the testator, the deceased, the person who has died. The executor's role is crucial in ensuring that the wishes of the deceased are carried out as specified in the will. The first duty of an executor is to locate the will and to ensure that it's the most recent version. Usually, the first place that an executor would go to find the will would be the home of the deceased. Sometimes, this step may not be necessary if the deceased gave an original will to the executor, because some law firms do prepare two identical originals of a will, but it is nonetheless a good practice to go to the deceased house to search for any newer versions if they do exist. Next, the executor must apply for a grant of probate from the family justice courts. This involves submitting the original will, the death certificate, a list of the deceased assets called the schedule of assets. In order to know the deceased assets, the executor should identify and gather all the assets of the deceased. This would include bank accounts, property, investments, personal belongings. You can watch my earlier video on the schedule of assets. In Singapore, most people approach a probate lawyer to handle their probate. However, a little known fact is that you can actually do probate yourself. If you Google Singapore Probate Toolkit, you will find a document issued by the Family Justice Courts which contains step-by-step instructions, including sample documents when applying for probate. But only adventurous people should do this DIY probate, because the frustration from not being familiar with the documentation and the inconvenience, of having to take half-day leave, take one-day leave in order to go to the service bureau to file the court documents, it may not be worth it, So some firms charge $1,000, some charge $2,000, $1,500. It is more of a convenience fee to save you the headache of, having to take annual leave to go to the court to file documents. Once the grant of probate is obtained, the executor is responsible for paying off any outstanding debts owed by the estate before distributing the remainder to the beneficiaries. In fact, the executor is required to sign an oath which has to be filed with the Family Justice Courts. And in the oath, O-A-T-H, he has to swear or affirm that he will dutifully pay off the debts and expenses of the deceased before distributing it to the beneficiaries under the will. Thereafter, the executor will distribute the assets according to the terms of the will. This may involve selling assets, transferring the property to one of the beneficiaries, and ensuring that all beneficiaries receive their rightful inheritance. It is important for the executor to keep detailed records of all transactions and all decisions made during the administration of the estate. The executor should prepare a final accounting to show the beneficiaries how the estate was managed and distributed. I will now move on to the High Court case that discuss the duties of an executor in a will. The High Court in Fujibu stated that an executor has to first call in, C-A-L-L-I-N, call in the estate and collects and converts the assets into cash and pays all the funeral and testamentary expenses, debts, and then legacies. When he has done this, he has discharged his duties as an executor. Then he steps into the shoes of a trustee. As a trustee, he owes a fiduciary duty to the beneficiaries, whether he's an executor or trustee. Executors retain the status of personal representatives so long as they have not acted in the capacity of trustees or made a declaration that they have taken on the status of trustees. The High Court went on to elaborate on the meaning of to call in and said that the executor has to determine the extent of the assets and liabilities of the deceased and then act diligently and reasonably in realizing the assets. Section 57(3) of the Probate and Administration Act allows for money from the estate to be used towards discharging funeral, testamentary, and administration expenses of the deceased. The High Court stated that testamentary and administration expenses are expenses incident to the proper performance of the duty of the executor and includes the costs of obtaining the grant of probate or letters of administration, including legal costs if there's any question of law or contest or whatever. The High Court then went on to discuss the duty of the executor to pay off the debts of the deceased with due diligence, having regard to the assets in their hands. This duty is owed to the creditors as well as the beneficiaries. The High Court stated that before distributing the deceased assets, it would be wise for the executor to protect himself by giving notice in the Gazette of his intention to distribute the assets. Under Section 29 of the Trustees Act, such a notice in the Gazette would require any person interested to send to the executor particulars of his claim in respect of the assets within a stipulated period that is not less than 2 months. The High Court stated that it's also the duty of the executor to keep proper accounts of the administration of the estate that they are dealing with. If called upon by the beneficiaries to render accounts, the executor is obliged to furnish, to give these such accounts and allow the beneficiaries to inspect the accounts. The accounts will be required to show the monies and assets received by the executor and how he dealt with these monies and assets. Finally, the High Court stated that it is the executor's foremost duty to act in the best interests of the beneficiaries when carrying out his duties or exercising his powers, in the sense that he must do his best to promote the beneficiaries' interests. When executor is to act for the benefit of a class of persons, such as multiple beneficiaries under a will, he must advance their common interests and has to hold the scales evenly among the beneficiaries. So thank you for watching this video on the duties of an executor under a will.